Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we look at the requirements of competency to sign a will. In New Jersey, the statute NJSBA 3B:3-1 sets forth that any individual 18 or more years of age who is of sound mind may make a will and may appoint a testamentary guardian. What are the requirements of a will? NJSBA 3B:3-2 indicates that a will shall be 1. In writing, 2. Signed by the testator, and 3. Signed by at least 2 individuals, and that's the requirements basically of a will. Let's see, now occasionally there are issues as to undue influence or competency. Let's see, and it reminds me of a time where I got a call from a client or a gentleman. He says, my dad wants to have a will, but he can't come in, he can't walk up steps. Can he come out to the house? And I said, that's fine, I'll see the gent, and of course we charge a fee to go out to someone's house. But I remember it was the first nice day of spring, the birds were chirping and the sun was out, and it was a nice day, and the son was waiting outside his dad's house because the son did not live with the father, and he brings me into the house, and the son says to the father, now Dad, this is an attorney, and he's going to explain to you why you should sign the house over to me. And the old man looks up and says, I'm not going to sign the house over to you. You'll kick me out and sell it to someone else. And that's when I found out the son never told his father that the attorney was coming over. So nowadays, let's see, we go to people's houses, we go to hospitals, but we want 2 things. Number 1, I want a note or certification from the doctor indicating the person is competent to sign whatever document is requested. And 2, I want to talk to the person ahead of time over the phone. Let's see, just to make sure that that's their wishes. And another time I got the note from the doctor that she was competent to sign a will, to turn the house over. And let's see, her son had mom called me up, and was son dial for mom. And I said, okay, what are you looking to do, Mrs. B? And Mrs. B says, I want to sign the house over to Johnny. Okay, Mrs. B, how many kids do you got? Mrs. B says, I have 3 kids. Well, Mrs. B, if you sign the house over to Johnny, that means Johnny gets the house and the other 2 kids get nothing. Is that what you want? No, that's not what I want. I want my all kids treated equal. All right, thank you, Mrs. B. And I had to speak to Johnny and say, sorry, Johnny, I can't do the will. Now, the Supreme Court in a case called Gellert versus Livingston set forth that there's a legal presumption that the testator was of sound mind and competent when they executed the will. The burden of proving undue influence is upon the person asserting undue influence, and it must be clearly established by the person who asserts undue influence. So a will typically is determined to be valid, let's see, unless a superior court judge determines otherwise. Let's say the New Jersey Supreme Court in the Gellert case also held the mere existence of a confidential relationship between the testator and the beneficiary does not alone create a presumption of undue influence. Let's say, and the other cases indicate that a parent does not need to make testamentary provisions for a child. That was Rayner versus Rayner, decided by the Appellate Division in 1999. I'd say it is also well settled that New Jersey law does not prohibit the disinheriting of an adult child. That was the case of In Re Anu, spelled A-N-A-N-U-E, which was decided by the Appellate Division in New Jersey back in 1998. So typically, now there's both the question of competency to sign the will, and there's also questions of undue influence. But the burden of proof is upon the person who challenges the undue influence. our appellate division in the case called the Matter of Landsman. Citation is 319 NJ Super 252, 1999. The court held testamentary capacity exists when the testator can comprehend the property he is about to dispose of, the natural objects of his bounty, the meaning of the business he is engaged in, and the relationship of other factors. Old age and the failure of memory do not themselves take away a testator's capacity. Another appellate division case called the Estate of Calvert Ostrom, they indicated that while courts found that parent-child relationships are among the most natural confidential relationships, the mere existence of family ties does not create a confidential relationship. So, in order to have someone challenge a will, they need to file a complaint. Order shall cause. The time periods are very strict, and I'd say it's highly recommended that someone retain an attorney immediately. For representation in probate and chancery matters, call the law office of Kenneth Vercammen, 732-572-0500 or 1-800-NJ-LAWS-7. That's NJLAWS 7. We're at 2053 Woodbridge Avenue, Edison, New Jersey. On the web at www.njlaws.com. That's NJLAWS.com. Thank you and have a great day.